Nafula, morning, are you there?
Yes, good morning.
Morning. How was your weekend?
It was good.
So let's give the others about 2 or 3 minutes that we begin.
Okay.
Good morning, Caleb.
Good morning, sir.
I think we can begin. The rest can join us as we continue. Let's have Caleb pray with us. Caleb, pray with us.
Let's pray. Kind and loving Master in heaven, we do come unto your feet this morning, thanking you for the gift you have given us. That's going to protect through this lesson, may be with us and enable us to understand. It's in Jesus' name I do believe and pray. Amen.
Okay, thank you, everyone. I hope you had a nice weekend rest and we are set for this week's work. And this is the second week, After this week, we have one more week to go, and I believe we will be able to complete the work that is expected of us on time. Now, last week, we were basically introducing ourselves, the concept of law, and we did define what law is. We did look at the purpose of law, did look at the functions of law and the principles of law based on the various definitions that we looked at. We also did look at the various sources of law, and critical in law is the enforcement of law. And so we had to look at the court system, which is basically the main system that is concerned with the enforcement of law. And then finally, we did look at public law, the aspect of the concept of public law, which is basically the administrative aspect of law. How is law administered? And we realized that in the administration of law, we have three levels of governance that are concerned with various aspects of law. We have the executive that is concerned with the administration of law. We have the judiciary that is concerned with the implementation of the law. And then we have the legislature, which is concerned with the enactment or the creation of law. And so these three wings of government or three arms of government plays a crucial role in any country. And so now we want to embark on the concept of mercantile law, which is basically looking at the commercial aspect of law, what we refer to as the commercial law. We want to look at the, we talk of various classifications of law. And we did say that among the civil law is the commercial law. And so commercial law constitute a number of laws which we are going to look at between now and next week, because that is the main focus of this particular course. We want to look at the transactional aspect of law, the law that addresses issues of commercial transactions, relationship between individuals who are in an economic relationship. So what aspects of law govern such relationship? Remember, we say that law is a set of rules that basically provide a guidance on the conduct of human behavior. And so this human behavior, remember, we said the other time that they are the ones that are concerned with the various levels and types of relationships that we have. We simply, when we talk of behavior, then we are talking of the nature of relationship that exists between or among individuals. And so we want to look at the set of rules that governs the commercial relationship among individuals or individuals who are in a commercial relationship. There are various aspects of this relationship that we'll be looking at. We'll start by looking at the law of tort. Now, I've made an adjustment in the e-learning. I've deleted the earlier presentation for law of tort and I've replaced it with another one. And so I hope you noticed that. The previous one had about 4 slides, but this one has about 40 slides. And so I think that was a mistake I did at the point of uploading. I've rectified that and now take note that we have a new slide for law of tort. In looking at the law of tort, we start by looking at the definition. What is a tort? What is a tort? In our day-to-day lives, we interact with people, and out of those relationships, you realize that certain things would happen that would probably hurt someone in one way or the other. And individuals get hurt either physically or emotionally. And so we have those different types, levels of hurt or harm that we could cause or that individuals could experience. Now, this is what we want to look at. In our day-to-day relationship, we have this kind of situation where we may find ourselves hurting one another intentionally or even without intending to do so. And you know, human beings being social beings, I hope you've done sociology, uh, we are bound to, you know, have frictions here and there. Now, some of these frictions that arises out of the various levels or types of relationship that we have a potential of causing some harm or as a potential of hurting other members or parties involved in such relationship. And so this is a common phenomenon. But then there is a possibility of one or two taking advantage of such, and this would probably occur on a regular basis and is prone to misuse or abuse by members. And so this is essentially the basis or the background of the law of tort. Now, an act which causes harm to a determinate person, whether intentionally or not being a breach of duty arising out of personal relationship or a contract, and which is either contrary to law or an omission of a specific legal duty or a violation of an absolute right. That is what a tort is. An act that causes harm to a determinate person. Now, when we talk of a determinate person, that's a person who can be seen, a person who has got that legal personality. Is a person whom we can make reference. And so when there's an act which causes harm to that person, and we are saying this act could either be intentional or may not be intentional. And this act is not it's not arising out of a breach of duty. It does not arise out of a breach of duty due to personal relationship or a contract. And it is either contrary to law, or it is an omission of a specific legal duty, or it is a violation of an absolute right. That is what we refer to as a tort. That is what a tort is. Now, every tort will result from breach of a certain duty which is primarily fixed by law. There are certain duties that are primarily fixed by law. And so when such duties are breached, when such duties are violated, then we talk of a tort. A tort would then mean that there's a violation of certain duty that has been fixed on a particular individual. Now, when that happens and this causes harm, then we talk of a tort. It is a duty not to defame someone. We have a duty not to injure someone, or we have a duty not to damage the property of any other person. And these are fixed by law. And so, should we defame someone? Should we injure someone? Should we damage the property of any individual? Then it becomes a violation of law. And this is what we refer to as a tort. And so causing defamation, causing injury, causing damage to property of any person is a breach that constitutes a tort. Whereas in tort, the duty is imposed on persons generally, and that is to mean that every individual has a duty imposed on them by law. And this duty, as I said, is a duty not to defame, not to injure, or not to damage any property of another individual. Such is imposed on every person. It is imposed on every individual. However, again, in tort, you realize that there are certain duties that may be imposed only on those parties that are concerned, such as the duties that are created by contract, which are imposed only on the parties to that contract and not any other person. And so similarly, the duty in tort is owed to every other person, unlike in cases of contract. And that is why we'll be looking at the law of contract separate from the law of tort, because the law of contract imposes certain duties to the parties involved in the contract, while the law of tort, mute your microphone. While the law of tort imposes a duty to all individuals in a general manner. So that is what a tort is. Now, a tort differs from other civil wrongs in a number of aspects. One of the aspects is that a tort is usually remedied by an award of unliquidated damage. Now, when we talk of unliquidated damage, we are talking of those damages whose quantum or whose assessment is left for the determination to a court at its discretion. That is what we refer to as unliquidated damages. The cost, the damage is left to be determined by the court at the discretion of the court. Now, in the law of tort, a person who commits a tort is referred to as a tortfeasor. And where we have two or more persons committing a tort, they are referred to as joint tortfeasors. So one who commits a tort is referred to as a tortfeasor. If there are two or more, then they are referred to as joint tortfeasors. And joint tortfeasors may be sued jointly, or any one of them may be sued for the whole of the damage. That is important, you take note of that. That the joint tortfeasors may be sued jointly, or any one of them may be sued for the whole of the damage. Now, in case of the joint tortfeasors, then there is a right of contribution. In the right of contribution, all the joint tortfeasors are required by the court to contribute towards the damage in a proportionate manner, or as apportioned by the court. So the court may apportion the damages between the joint tortfeasors in such a way that is just. And of course, bearing in mind the degree of blame that each one of them would be responsible for, or the degree of blame that is apportioned to the joint tortfeasors. In that way, then the court will determine how to apportion the damages to those joint tortfeasors. What are the functions of the law of tort? Number one, it is to determine the rights between parties to a dispute. A particular dispute may bring an action for a declaration of his right or a right. And once the court makes such declaration, then the rights of the parties are deemed to have been determined. And so that is one of the functions of the law of tort. When we have parties having a dispute, and they need to settle that dispute through a declaration, the court can come in and make a declaration on the status of that dispute. And this declaration is basically a declaration on an action on the rights of individuals, or a determination of the rights of an individual, so that it becomes easier to know whose rights have been violated, who has been injured, whose property has been damaged, or who has been defamed. And so the court comes out and make a declaration, and such a declaration is deemed to have been used to determine the rights of the parties involved. Secondly, the law of tort ensures prevention of continuance or repetition of a harm. If just left like that, then people could continuously cause harm to others, could continuously injure others, or could continuously cause damage to properties of individuals. And so the law of tort comes in to prevent that continuous or repetition of a harm. When the injury complained of is of a continuous nature or is likely to be repeated by the tortfeasor, then the injured party may be granted an injunction. An injunction is a stoppage, is a declaration requiring that one brings to an halt an action that has been made. So when one seeks for an injunction and is granted, then it bars, it stops the tortfeasor from continued injury or harm, damaging or causing harm to the person. It prevents the continuous or repetition of an. So that is another function of the law of tort, so that we can stop continuous hurting or repetition of an act that causes injury, that causes hurt, or that causes damage to a property. Thirdly, it is to protect certain rights that are recognized. There are certain rights which every individual is entitled to as enshrined in the law. Now, the individuals are entitled to these rights, and these rights are recognized by law. These rights are therefore protected by the law of tort. And that is one of the functions of the law of tort, to ensure that these rights are protected. The rights that are recognized by law and enshrined in the Constitution and enshrined in the law must always be protected. The law of tort ensures that these rights are protected and remain. For instance, the reputation of a person or the right to a good name is protected by the tort, which then imposes a duty of care on every other person. And finally, it is to restore property its rightful honor. As you say, it is to the law of tort ensures that it prevents damage to property. And so where property is wrongly taken away from its rightful owner, or otherwise detrimentally to his right, the person may seek for a restitution of the property or the value, since the wrongful act amounts to the tort of trespass to goods or trespass to land. And so the law of tort functions to restore property to its rightful owner. What is the nature of a tortious liability? A tort is a civil wrong, which is usually remedied by a word of unliquidated damage. And that we have to. Now, a tort or tortious liability would arise from the breach of a duty that is primarily fixed by law. Now, such duty is towards person generally, and it is breach, and its breach is redressable by an action for unliquidated damage. And so every person is under duty to compensate for their wrongful act, which may result in an injury to another person. It is this duty to compensate that determines the liability of the tort in tort. So that duty is what determines the liability. In determining the extent or level of liability in tort, there are two principles that would always govern that process. The principles are one, the damnus in injuria, and the injurious in damno. Now, damnum in injuria refers to a circumstance where a person has suffered actual harm without any violation of his legal. There are instances where one suffers, one suffers actual harm, but their rights are not violated. That is what damnum in injuria implies, that it is possible for one to suffer an actual harm without the violation of the. There are circumstances where individuals would suffer actual harm without the violation of their legal rights. A person may be aggrieved even where he has no legal remedy. And so that is damnus in injuria. There is a damage without there is an harm that has been caused, but there's no violation of the legal rights of the person. You see, for instance, when we have competitors, business people competing, two business people competing, and one uses this way to get customers. You know, one could stand at the entrance of another competitor, so next to a competitor business premises, and then entices customers instead of getting into the business premises of that other competitor, they get into his. Now, there's no right violated of that other competitor by you enticing clients to leave the other person's car, the other person's business, and come and buy from yours. Or basically what matatus do, if you've experienced what matatus normally do, the manambas, they'll come and snatch people and get them into their vehicles, or get their luggages into their vehicles, and then the person is forced to come in. May even alight from another vehicle because they want to get to the vehicle where their luggage is. Now, in such a case, the other vehicle would be dealt an actual harm. They'll lose financially. There will be an actual harm, but there will be no violation of their legal rights. It's not their legal right to have that person board their vehicle. It is not a legal right of any business person to have clients walk into their business. But certain acts may cause harm to them. Such act could be deemed to be a violation, could be deemed to be a tort, and a tortious act. And so that is damnus in injuria. There is an actual harm suffered, but there is no violation of any legal right. You could suffer actual harm without your rights being violated. So that is the first principle, damnum in injuria. Then we have the injurious in dumno, which refers to a situation where a person suffers a violation of his right without any actual harm or loss or damage caused to that person. That is injurious in damno. You suffer a violation of your rights without actual loss or damage being sustained to you. So that is the second situation, you know, in cases of actionable per se, you know, they don't need proof of any damage, like trespass to land. In trespass to land, someone would violate your rights, but there will be no actual loss or damage sustained. When someone trespasses your land, when someone walks through your land without your permission, it's a violation of your rights, because you have a right to enjoy your property as you so desire. You have a right to decide who partakes of your property and who doesn't. But that will not cause any actual loss to you. You don't lose anything. There's no damage that would be sustained by you. But the fact of the matter is your rights have been violated. And so that is the principle of injurious in dumno, which is very important. These two principles are applicable in determining the tort liability or tortious liability. In determining whether there's a liability in tort, we look at the damnus in injuria and the injurious in damno. Someone could suffer actual harm without the violation of their rights, or someone could suffer a violation of their rights without suffering actual loss or damage to their property. Both principles are key in determining tortious liability. Further, in the determination of tortious liability, there are other principles that are useful, that would be used to determine whether there is a liability existing. Number one is the fault principle. The fault principle. Now, you see, under this principle, it is necessary to establish some fault on the part of the wrongdoer before he can be made liable in tort. And so we are asking ourselves, who is on fault? Is it the wrongdoer or the person who has been wronged? So that is the fault principle. It is important that we establish that the wrongdoer had some fault on his or her part. And it is not the person who was wrong who, if it is who is wrong, who is at fault, then the person cannot bring an action against the purported wrongdoer. And so this is what just a minute. So this is the fault principle, that the person, the wrongdoer, has some fault on his or her part. It is that that of conduct set by law. If someone fails to live up to such ideal standard of conduct that have been set by law, then the person is said to be at fault. We have three elements that are relevant in the determination of fault, and any of them may be relied upon in determining the tortious of an individual. Number one is intention. The first element in determining whether a wrongdoer is at fault or there is fault on the part of the wrongdoer, then we look at the intention. Intention, when a person has a wrongful act desiring that its consequences should follow, then the person is said to have intended that to happen. If it was a desire, if it is established that the act that has been committed was an act that was desired, and the consequences of the act was known, and was the desire that the consequences be made, and the person is said to have intended. So there was an intention. Now, to the extent, Wahid, mute your microphone. Now, to the extent that it can be established that a person did a wrongful act and desired that the consequences be followed, then the person had an intention. The person intended to commit that act, and so the intention is in such a case, to the extent of that intention existing, then we say the person is at fault. But if you cannot establish the intention, it was not intended, then we cannot say the person is at fault. Number two is recklessness. An act is said to be done recklessly where it is done without caring whatever the consequences might be. When you don't care, when an act is committed without due care on the consequences, then we say that that is reckless. And so when that is established, at fault. Now, recklessness constitutes a fault on the part of the wrong. When it can be established that the person was reckless, then is a fault. And finally is negligence. A person is at fault where he does a wrongful act negligently. Where one does a wrongful act negligently, then the person is deemed at fault. There are those circumstances such that one ought to have done something, or ought to have seen the consequences of their act and avoided it altogether, but they did not do that. That is what negligence means. You are in a position to see the consequences, and could have avoided it, but you decided not to avoid it and proceed with the act, knowing very well the consequences of such an act, then it is said to be negligence. And so the person is again at fault. We also need to distinguish between tort, crime, and a breach of contract. All of these are civil wrongs, yes, but there must be a distinction between them, so that where a crime has been committed, we don't talk of a tort. And where a tort has been committed, we don't talk of a crime. Where there is a breach of contract, we treat it as a breach of contract. And where there is a tort, we treat it as a tort. You know, if it is a breach of contract and you bring an action against tort, an action of tort against the person, then it will not succeed. If it is a tortious act and you bring a breach of contract, you sue for a breach of contract again, it will not succeed. And so it is important, it is imperative that we be able to determine whether an act is a crime, is a tort, or is simply a breach of contract. Now, an act, a crime, is a breach of public rights, whereas a tort is a civil wrong. The main objective of criminal proceeding is the punishment to the criminal person. But the objective of proceedings in tort is not to punish, rather it is to remedy. Is to remedy the damages. So that's the distinction between a crime and a tort. A crime is a breach of public peace or a breach of public rights. A tort is simply a civil wrong. And civil wrong, remember from the other time when we're looking at the classification of law, civil wrong is simply a wrong that is committed to a private person by a private person, a private citizen by a private citizen. It is a violation of the rights of a private citizen by another private citizen. That is a civil law. Now, the main objective of criminal proceeding is actually to punish the wrongdoer, to punish the wrongdoer for the criminal act that they have committed or for the crime committed. While the main objective of tort, the main objective of bringing a proceeding of tort against a person is actually to remedy the wrong that has been done. To remedy the wrong that has been done. To remedy the damage. To remedy the injury that has been caused. Then we have the breach of contract. In a contract, you know, we have, in any contractual relationship, the duties of the parties involved are fixed by the parties to that contract. And therefore, in a contractual agreement, the duties are fixed by the parties to the contract. A violation of such duties constitute a breach of contract. The violation of the duties that has been fixed by the parties to a contract is what constitutes a breach of contract. But remember earlier on we said that in tort, the duties are actually created by law. The duties are fixed by law, either common law or some legal statute would establish them. And therefore, a breach of those, a violation of those, not a breach, but a violation of those laws that have been fixed by law, a violation of those duties that have generally been fixed by law is what constitutes a tort. However, it is important that we take note of this, that in some cases, a breach of contract and a tort may take place simultaneously. It is possible that one can commit a breach of contract and the same breach of contract may constitute a tort in a simultaneous manner in some cases. And so it's important we distinguish between those two aspects. Now, for instance, we assume that employees to operate on a patient. In that case, you say, if the surgeon who has been contracted to perform the process or the procedure on a patient fails to carry out the procedure, then it constitutes a breach of contract. And to the extent that the surgeon, fails to carry out to conduct that procedure on the patient as he or she had been contracted, then it's a breach of contract. But again, you know, it could also be a tort of negligence. If anything, should anything happen to the patient and dies, then you can sue for negligence. And so an act can simultaneously be a breach of contract and be a tort at the same time. So we need to understand that, and being able would help us to know the difference. Now, in tort, we have the following defense. Whenever an action of tort has been brought against, we have this set of defenses that are available to defendant in every act of tort as appropriate. Remember, it's not general, but you need to determine its suitability or where it is appropriate to be used. So among the defenses that are include volentin and fit injuria. We have the defense of volentin and injuria. Now, the defense of volentin and fit injuria is generally known as the assumption, the voluntary assumption of a risk. That is volentin and fit injuria. We have instances where someone voluntarily assumed the risk, and it's possible that a defendant may plead the defense of volentin and fit injuria. In pleading for the defense of volentin and fit injuria, the defendant, in effect, would be saying that the plaintiff actually consented to the act that is now being complained about. And the consent may be either expressed or implied out of their conduct or out of the conduct of the plaintiff. And so the defense of volentin and fit injuria can be used. If there is voluntary consent, if the person knew the risk involved, but consented either expressly or by their conduct, the conduct of their behavior, they are assumed to have understood the risk involved in the act, but they all together consented and proceeded with an act, which is now being brought against the defendant in a case of tort. A good example is, you board a bus and the bus is full, but you just tell the number, let me just get in, as many of us do. In such an instant where the bus is full, should the bus be involved in an accident, the insurance will not be able to compensate the excess passengers. Why? It is assumed that the passengers knew the risk involved in boarding an excess vehicle, but they all together went ahead and assumed the risk and consented that whatever happens, they are ready to take care of it. Or you've seen the other time we had a number of floods, and a number of vehicles were swept away, unfortunately, and a number of lives were lost in such instances. When such happens, be sure that there'll be no compensation. Why? Because it is assumed that the people knew the danger. You remember there's this one clip that was going around and they were saying they are going to die. They boarded a lorry and they were even told these ones are going to die. But they all together went ahead. Unfortunately, the lorry was swept away by the floods and all of them died. So in such cases, there's no compensation. You cannot be compensated for. Just like, again, you bought a pickup at the back of it, and you know very well that the back of the pickup is not insured for passengers. It is insured for luggages. But you go ahead, accept and board. Should anything happen while you are seated at the back of the pickup or at the back of the lorry, again, you cannot be compensated. That is a case of volenti non fit injuria. Another example is when it comes to sports. It is assumed that generally before you engage in any sporting activity, you know the risk involved. If it is rugby, you know the risk. If it is football, you know the risk. If it is motor racing, you know the risk. If it is hockey, you know all the risk involved. And so the moment you participate as a sportsman and an injury is caused in the process of partaking of that sport, you cannot be compensated. Why? Because it is assumed that you voluntarily assumed the risk. So if you are a player in a football club, you cannot sue a football club, for any injury sustained in the field. If you are a rugby player, you cannot sue any rugby club for injuries sustained while in the field. Why? Because it is assumed you voluntarily accepted to bear the risks that are involved in that particular activity. If you board a vehicle, knowing very well that the driver is drunk, it is assumed that you are voluntarily assume the risk associated with being driven by a drunk driver. So should anything happen and it is proved that the driver was actually drunk at that time and it was known to you, then you cannot claim for any compensation. So that is the defense of volenti non fit injuria. And then the other defense is inevitable accident. Inevitable accident is the other defense that can be brought. In inevitable accident, there are actions, there are acts which cannot be prevented by the exercise of ordinary care, caution, or skill. If an accident could not be prevented by the exercise of ordinary care, by the exercise of ordinary caution and skill, it occurs without any negligence on the part of the person whose act is complained against, then we can talk of an inevitable accident. Now, because in an inevitable accident, there's no fault on the part of any person. And yet the principle of fault is key in determining tortious liability. Now, when there is no fault, then it becomes an inevitable accident because it does not impose fault on the part of any person. Then the third is act of God. There are those acts that are inevitable accident but are caused by natural forces that are not in any way connected with human beings. They're act of, like a storm. You see, if there's a storm and a storm brings down my tree and it falls into the neighbor's roof and causes a damage, I did not cut the tree. The tree was planted there, it has been there over time, it was not considered to be any risk. It was not considered to be of any risk. But then from nowhere, a storm comes and the storm brings down the tree and the tree falls on my neighbor's roof and causes a damage to the roof. It is not possible to be sued for that because I did not bring the storm. Or flooding occurs. And when a flood occurs, maybe I have my water dike somewhere there, or I have my water pan and the water pan floods and overflows onto my neighbor's land and carries with it the food, the plants in the neighbor's land, it's not possible to bring an act of tort against me for the flooding that came out of my water pan. Why? I did not bring the rains. It's an act of God. So you cannot sue for, you may have artificial lakes and your lakes overflow due to heavy rains. It's an act of God. You don't control rain. Then the other defense is necessity. There are certain acts that are committed out of necessity. One may be forced to interfere with the rights of another person so as to prevent either harm to himself or to his property. Then that is an act of necessity. There are certain actions that are committed out of necessity. They are done. You violate someone's right so as to prevent an harm to yourself or to your property. That is an act of necessity. This defense, though difficult, but there are instances where it may be sustained by the courts of law. Then we have self-defense. You can also plead for self-defense. It is sometimes said that a person who is attacked does not owe his attacker a duty to escape. A person who is attacked does not owe his attacker a duty to escape. And therefore, everyone whose person is threatened is entitled to defend themselves. And in defending themselves, they may use force. That force may cause harm to another person. For as long as the force is reasonable, then they are not liable to the attack. But if they use unreasonable or excess force, for instance, if someone comes and wants to hit you with a cane, and you decide to shoot that person, then you have used excess force. The force you've applied is unreasonable. When someone has come and he wants to hit you with a stick, then you also defend yourself using a stick or something that is reasonable. When someone attacks you using machetes and those dangerous weapons, then you can shoot. But you cannot shoot someone who just comes to you with a stick, with a rod, and then you shoot. No. It will be deemed that the force is excess and was unreasonable. And that is why in cases of protest, where the protesters are not harmed, then the law enforcement officers are not allowed to use bullets, live bullets. They can only use rubber bullets, because then their lives are not endangered. They're simply trying to, dispel the protesters. Nobody's life is in danger. But when the protesters are harmed and they have all manners of crude weapons, then the law enforcement officers, the policemen and women, are allowed to use force that is reasonable. They're allowed to use a force that is reasonable. You can disperse protesters using tear gas. That is enough. That is reasonable force for unharmed protesters, unharmed demonstrators. Just use the tear gas. Just use, that hitching water. That seemed to be reasonable. But when the demonstrators are just walking around demonstrating and you decide to shoot live bullets, then you'll be held liable. And that is why you always see policemen who are taken to bring order in cases of demonstration can be sued, because then they have used excessive force, unreasonable force. So you can use self-defense. The other defense is mistake. There is a defense of mistake. Now, the general rule is that a mistake is no defense in tort, whether it is a mistake of law or a mistake of fact. However, a mistake of fact may be relevant as a defense to any tort is in some exemptional cases. For instance, where there is a case of malicious prosecution, where there are cases of false imprisonment and deceit, then you can use a mistake. For instance, a case where police officers arrest a person who is about to commit a crime, but the person arrested is an innocent, then the police officers may use the defense of mistake. They arrested the person by mistake. Despite the fact that the person is innocent, the police could plead for mistake and he could be set free. And finally, we have statutory authority. There are instances where an act is committed by a person who is authorized by a statute to commit that particular act. And so when an act is committed by a person who is authorized by some statutes, by some law to commit that particular act, you cannot bring an act of tort against such a person. A good example is, policemen are allowed to arrest. When they arrest and they have a warrant of arrest, then you cannot sue them for any harm caused to you. You cannot sue them for defamation, for injury, because they committed it out of an act that has been authorized to them. It is assumed that authorization of an act is also an authorization of its natural consequences. However, we must be careful that when we are committing an act that has been authorized, we must do it out of good faith. It must be done in good faith, and it has to be done within the scope of the powers that has been conferred by that statute. Otherwise, if we use power that is beyond what has been conferred by the statute, or there is no good faith, then we will not be protected by that same statute. And that's why judges, they can commit certain acts which ordinarily would be deemed to be tortious, but because they have committed them in the course of carrying out their duty as judges, they may have committed it out of carrying out their duties as policemen and policewomen. You cannot bring an act of tort against, because they could easily plead for statutory authority. Where a person has acted in pursuance of the provision of a statute, then the person may plead statutory authority in their defense. And where the statute does not protect the person from liability, in cases where they have used excess powers than what has been bestowed on them, and the injured party claims by way of compensation a sum in excess of the stipulated by the statute, then the statutory authority mitigation could come. So in that case, then we talk of statutory. In tort, it is also important that we consider the capacity to sue and the capacity to be sued. We have various individuals involved. We want to know what is their capacity when it comes to sue and to be sued, because that is very important. The general rule is that any person may sue or be sued in tort. However, some special rules apply in certain circumstances, which therefore restrict or forbid or qualify the right to sue or to be sued. And that is certain persons cannot sue, while some other persons cannot be sued. The capacity to sue and to be sued simply means the capacity of parties or persons to sue or to be sued in law of torts. We look at various persons. We'll start by looking at the capacity of the government. Now, the Government Proceeding Act, Cap 40, makes the government subject to liabilities in tort as if it were a private person of full age and capacity. Section 4, subsection 1 of this act provides that the government is liable, 1, in respect of torts committed by its servants and agents. And that is why the government can be sued when a servant or an agent of the government commits a tort. You've seen the government being sued because of an action of a police officer. You've seen the government being sued because of an action committed by another servant of the government, by the Attorney General, by the Inspector General of Police. All these instances comes up. And so the government is liable for prosecution in tort for any act in respect of torts that have been committed by the servants or the agents. Number two, in respect of any breach of those duties which a person owes to his servants or agents at common law by reason of being their employer. That for that reason, you've seen government employees suing the government in a number of instances. You've seen the other day, the JSS teachers went to court, they sued TSC and the government, and the courts pronounced themselves that whatever the TSC and the government was doing in terms of internship, having the junior secondary school teachers on internship is wrong, because the law of Kenya doesn't provide for teachers to be on internship. It doesn't require them to be on internship. You know, the law requires that before one is licensed to practice as a doctor, as a clinical officer, or as a nurse, clinical officer, or as a doctor, then they have to go for internship. That is a legal requirement. The law requires that before someone is admitted to the bar, they have to undertake pupillage. That is a requirement. But the law doesn't require that before someone is registered as a teacher with the TSC, then they have to go for internship. And that is why they sue the government, because all the JSS teachers who were not previously employed by TSC were engaged as interns. But then the law doesn't have provision that teachers would go for internship. And so they sued and they won the case. And thirdly, in respect of any breach of the duties attaching at common law to the ownership, occupation, possession, or control of the use of property, you know, when one is denied the right to use their property, they can sue the government. When the government denies them the right to enjoy or use their properties, then they are capable of suing the government in that instance. The second category of special person is the infants and minors. As a general rule, minority is no defense in tort. Infants can sue and be sued in the same way as any other person. Remember, this is a civil wrong, it's not a criminal. It is not a crime, it is not a criminal wrong. It's a civil wrong, and so there are certain exemptions. However, the age of an infant may be relevant in some torts where intentions, malice, or negligence of the wrongdoer are the main cause of the tort. Because at that age, they may have not developed the will to create some intention, the will to establish the consequences of their act. They may not. You know, infants may not be able to. They may not be able to foresee the consequences of certain acts. They may do it innocently, not thinking of the consequence of doing that. And so in cases where the intention is a main cause of the tort, or cases of malice, or cases of negligence, because this comes out of being in a sound mind position. An infant may not be in a position to envision the consequences of their act. So in such instances, such torts, then you cannot sue an infant for that. Secondly, in the case of negligence, the infant may not have reached the stage of mental development where it could be said that he should be found legally responsible for his negligent act. And so in such instances, again, of negligence, then where negligence is the main contributor to the tort, you cannot sue because the person is deemed not to have developed a mental capacity to legally be responsible for their negligent acts. Generally, a parent or a guardian is not liable for the tort of his children unless he or she authorizes the tort. Where a tort has been committed by children, the parents or the guardians cannot be held liable unless it's an act that the guardian or the parent authorized the child or the infant to do. But a parent or a guardian is liable for torts committed by children in negligence if the parents are deemed to have been negligent. Then the parent would be sued. Like cases where we've had children having having guns and shooting their colleagues. It has taken place several times in the US. The parents of those children, as long as the children are underage, it is deemed that the parents allow them to have their guns. And so it's an act of negligence on the part of parents to have allowed their children to have those guns. If a parent allows a child, for instance, to drive an underage child and the child causes an accident, then it's an act of negligence on the part of the parent. And so the parent would be sued, would be held liable for those torts that have been committed by their children in negligence. Husband and wife, a married woman is liable in tort and may sue or be sued in tort in the same way as though she were a female soul or a single and married woman. A wife can sue her husband in tort for the protection of her own. The Constitution of Kenya, Chapter 14 provides that the President of Kenya is not liable for any proceedings whatsoever in any court. There can be no civil or criminal proceedings instituted against the President while still in office. And so, again, there is a limitation to sue or to be sued in tort for the President because the President is protected by the Constitution. Heads of state and diplomats, the heads of foreign states, diplomats of foreign missions, and certain other persons who are connected to them are always immune from the jurisdiction of the local courts as provided by the Vienna Convention of Diplomatic Relations of 1961. And of course, the relevant articles of which are given the force of law in Kenya by the Privileges and Immunities Act 179. There are those diplomats, heads of states, foreign states and diplomats, and their relations are always provided with that immunity from local jurisdiction, from the jurisdiction of the local court. So they cannot be sued in those cases, either in tort or in criminal offense. So they enjoy that immunity. Then we have corporations. Corporations can sue, and they can be sued in their own names. They are therefore liable to actions in tort. A corporation is also liable for torts that have been committed by their servants or their agents, as long as those actions have been committed within the powers provided to those servants and agents, and they have not committed an act ultra vires, then the corporation can be sued for those tortious acts. But if an act has been committed ultra vires beyond the powers that has been provided by that to that servant or to that agent, then the corporation cannot be held liable. Similarly, a corporation cannot be held liable for some torts of personal nature. There are some torts that are personal in nature. The corporation cannot be held liable. For instance, if someone has a fight within the premises of an organization and the fight was personal, if an injury is caused to to any person involved in that personal fight, then the corporation cannot be held liable for any injury. But if someone walks into the premises and the floor, for instance, is slippery, And as one slips and, because of the slippery floor, they hurt themselves, then the corporation can be sued in such instances. Trade unions, they have the capacity to sue in tort. However, actions against them in tort are limited. Section 23 of the Trade Unions Act, Cap 233, provides that no action shall be brought against a trade union for torts committed by its members or officials in respect of any act done in contemplation or in furtherance of a trade dispute. So in such instance, if the act was done in contemplation or in furtherance of a trade dispute, then you cannot sue a trade union. Persons of unsound mind, they are generally liable in tort unless intent is a necessary element and their condition is such that they could not have formed such. So where intention is key to determine the tortious liability, a person of unsound mind cannot be in a position to create an intention, then they cannot be sued. However, generally, where intention is not required, then they can be sued in tort. Then we have aliens or non-citizen. An alien is under no disability and can sue and can be sued. However, an enemy alien cannot sue, but they can be sued, and when sued, they can defend themselves. But then they cannot sue aliens of enemy countries. They can be sued, but they cannot sue. Finally, we have judicial officers. The judicial officers are protected from civil liability for any act done or ordered by them in the discharge of their judicial function. Therefore, judicial officers or officers of the court are also protected against civil liability for acts done in pursuance of a judicial order or in pursuance of a warrant. So they become protected. We have different types of torts. Before we look at the torts, any questions so far? We've looked at what a tort is. We've looked at remedies in tort. We've looked at capacity to sue of various individuals. Any question before we look at the specific torts and their remedies? And of course, looking at the remedies is, while we look at the remedy, it is also important that we look at also the defenses that are available. We've looked at those defenses and we look at the specific remedy for the specific torts. Any question? Yes, Finas.
Okay, my question comes on the features that you explained. I think the joint and the personal features. Would you please go back again and do something on it? Didn't get it well.
What we mean is when a person commits a tort, then if the person is one person, we refer to that as a tort person. Is that clear? Finas, up to there, are you okay?
Yeah, I'm okay up to there.
When a tort has been committed and it has been committed by a single person, we refer to that as a tort person. Okay? Now, an act of tort or a tort can be committed by two or more persons. When a tort is committed by two or more persons, those who have committed that tort are referred to as joint tort feasors. Up to there,
Oh,
are you okay?
yes, yes.
Now, when a tort has been committed by a single person, by an individual, in which case we refer to as a tortfeasor, then that individual would be sued for that tort. And the person becomes solely liable. And the person who is solely liable becomes liable for the damages. The person would be called upon to remedy, would be called upon to pay for the damage. Remember, we talk of the remedy in tort is unliquidated damage. That means the value of damage is determined by the court at their discretion. And so at the point where the court has determined the value or the extent of damage, the tortfeasor is required to make a payment to remedy that damage. He will do it wholly. He'll do it as an individual. Is that clear?
Yes, so
Now,
unliquidated damage means that
uh-huh.
unliquidated damage means that the court determines the level of damage that was made.
Yes.
Okay.
You know, we have liquidated damages. Liquidated damage is a case where the cost, the value, is either fixed by law. You see, there are cases where they say the fine not exceeding 10,000 or 2 months imprisonment. It is defined. It is already determined. Or is a breach of contract, and you are supposed to have performed a contract worth 10,000. You've not done it. The value is fixed at 10,000. The value of the contract that is liquidated. It is already determined. But unliquidated, it is left at the discretion of the court to determine. Okay?
Yeah.
Now, in joint tortfeasors, one can sue them individually, jointly. Okay? If there were 2 or 3, all the 3 could be jointly sued. When they are sued, the court will determine the extent of damage that each one of them will be required to remedy in accordance to the portion of blame of each person, or the part of blame that can be apportioned to each one of them. One can decide and sue all of them, the 2 of them, the 3 of them. Or one can decide and just sue one of them. But when the court determines the damage, the court would apportion the damage to all those who are involved, including those who are not sued, if they were joint tortfeasors. Up to there, is it clear now?
Yes.
Okay, so I think I've addressed it, unless you still have any other concern.
Yeah. Do we have an explanation on that, or in the notes, in the e-learning?
Unfortunately, I told you that the materials in the e-learning are just as brief as they are. There are elaborate explanations in the textbook.
Okay, okay.
Yeah, so those who have it will find all those elaborate explanations. You know, I cannot put everything in PowerPoint. That is not the role of PowerPoint. PowerPoint is simply to guide you so that you know what you need to discuss. Okay, but in the textbooks, they are there are even illustrations. There are cases that have been used to illustrate some of these, which you can give you better understanding. Okay, and so far I think is only Celestine, Otunga, Davis, and Osborne who have managed to acquire a copy of the textbook. So the rest, I've not heard from you. Any other question? Okay, then if there's no question, let's take a short break. Let's take a short break, about 10 minutes, and then we begin. Let's come back about 5 minutes past 10. We begin the second session where we'll be looking at the specific torts. Okay, welcome back. I hope all of us are back. Are we all in? Finas, are you there? Okay, see Caleb is
Yes,
in.
I'm around.
Yes, is in. Osborne, are you there?
Yes, I'm here, sir.
Okay, Mutumo.
Yes, I'm in.
Okay, Nafula.
Yes, I mean.
Okay, so everybody's in. We can continue. Now, we want to look at the specific torts. We have various different types of torts, as I had mentioned earlier, ranging from trespass, nuisance, negligence, and defamation. The main four types of torts that we'll be looking at is the tort of trespass, tort of nuisance, tort of negligence, and then tort of defamation. And of course, we'll also look at the malice. There's an aspect of malice, which will come out clearly when we'll be looking at defamation, though we look at it as a different category. Now, remember that the one people wrong committed by different persons. And so the specific torts include tort of nuisance, tort of negligence, and tort of defamation. It is important that we look at the various characteristics of these torts, look at the damages that can be pleaded for, and also look at the defenses for each one of them. You'll find that there are damages that cuts across, there are defenses that cuts across, while in some instances, you'll find that there are some defenses that would be specific to that particular tort. There are some damages that would also be specific to that particular tort. But we'll look at all of them, we'll try and identify which defenses are suitable under which tort, which remedies or damages can be pleaded for under which particular tort. And so we start by looking at the tort of trespass. The tort of trespass, when you talk of trespass, you know, one thing we need to understand is that trespass is actionable per se. Actionable per se simply means it is actionable without proof of any damage. The moment it is established that a trespass has been committed, we don't need any proof. The plaintiff will be entitled to legal redress whether or not the plaintiff suffered actual damages. And so it is immaterial as to whether the plaintiff suffered actual damages. As long as it has been established that a trespass exists, a trespass has been committed, then that is adequate. We have three types of trespasses. We have trespass to land, we have trespass to the person, and then we have trespass to goods. So a trespass can be committed against the land, against the person, or against the goods owned by a person. When we talk of trespass to land, we are talking of an act of trespass has been committed where a plaintiff's possession of land is wrongfully interfered with. And in trespass to land, the major thing is on the possession of the land, where a rightful possession of a land has been interfered with, then a trespass has occurred. It has nothing to do with ownership. It is simply on the possession. And so the actual damage, the cost here is on possession. And it is immaterial to consider whether there is the owner or not the owner of the land. And that is why when it comes to rent, one of the tribunals that we have when we're looking at the judicial system is the business premises and rent tribunal. The moment someone rents a house, they are entitled to using it. They're entitled to possession, not ownership. And so a landlord cannot come and curtail their use of that particular premises. If a landlord comes and interferes with their use, then we are talking of a trespass to land. And so it is immaterial to look at the ownership. The point is on the possession. As the rightful possession being wrongly interfered with, that is the question to be determined in a trespass to land. Trespass to land is normally a civil wrong. However, in some instances, it can give rise to criminal proceeding. Remember, as we said earlier on, there are certain torts that can be regarded as both civil and criminal. There are certain torts that can be regarded as both civil and criminal. One of those is the trespass to land, which we have different types. Okay, the Trespass Act Cap 294 states that a trespasser can be prosecuted criminally if he enters on somebody's land with intent to steal goods or commit any other offense. Otherwise, a trespass to land is a tort and as such is actionable per se, and we don't need any proof of special damage. We have the one of them. We have there is physical, even if it is just a slight contact, then we talk of trespass by wrongful entry. Trespass by wrongful entry would include acts like encroaching on the land, walking through the land without authority, sitting on the plaintiff's fence, putting a hand through a window which gets into the plaintiff's land or space. It could also be an abuse of a right of entry. It can also constitute a trespass by wrongful entry. You know, instances where a person who is authorized to enter certain premises, maybe for the purposes of repairing them, then they can become a trespasser when they pick or eat food without permission in that house, when they do any other thing without authority. If they misuse the authority that has been given to them when they were granted access to that particular property, then we talk of trespass by wrongful entry. We can also, trespass to land can also take place by remaining on land. So we have trespass by remaining on land. This trespass by remaining on land is committed by a person who, having been originally authorized access to the land, or who had been originally authorized to enter the land, subsequently has been asked to leave after that, but then they failed to leave without any reason, within a reasonable time, then they are considered to have trespassed, and that is trespass by remaining on land. When you are invited into someone's house and you decide not to leave within reasonable time, you can be considered as a trespasser, and so that is trespass by remaining on land. Initially, you may have been authorized access to the land. You may have been authorized to access the land to stay there, but you are required to leave within reasonable time. If you do not leave within reasonable time, then it constitutes trespass by remaining on land. That is trespass land. Then we have trespass by placing things on land. You can have trespass by placing things on land. Now, Trespass by placing things on land is committed by an individual who places any material things on the plaintiff's land, or who allows such material things or noxious substances to come into contact with or cross the boundary of the plaintiff's land. Now, trespass by placing things on land is similar to nuisance in a number of ways. It's similar to nuisance. However, they differ in two respects. One, in trespass, the injury is direct since it affects the plaintiff's possession, while in nuisance, the injury is indirect as it is the plaintiff's comfort and convenience in the use and enjoyment of their land that has been interfered with and not possession. And secondly, while trespass relates the possession of land, nuisance relates to the use or enjoyment of the land. So that's the main difference. Then we have trespass by relation. Again, this is another form of trespass to land, trespass by relation. The plaintiff's possession of land relates back to the time when he first acquired a right to possess the land, and therefore is deemed to have been in possession of it from that time. The possessor of land may therefore sue any person who committed an act of trespass on the land even before he himself took actual possession, since it's the plaintiff's right of action that is based on the title, which legally relates to the person. What are some of the, now, as we have said earlier, trespass to land can both be a civil wrong, can be a tort, and can also be a crime to some extent. So we need to understand the extent to which it becomes a crime and the extent to which it's a civil wrong and therefore a tort. What are some of the defenses in the trespass to land? We have defenses such as prescription. Prescription is a situation where, a land that has been acquired by possession is said to have been acquired by prescription. And therefore, the new owner will plead title by the prescription as a defense to an action that has been brought by a previous owner, if any. So if a land has been sold and a new owner has come in to possess it, you cannot sue, because the person would simply come and plead for prescription. Is the new owner, he has acquired the title and now he wants to use it. And so the question of you have been wrongfully denied possession do not come up, because the possession was granted by a previous owner. A new owner is entitled to use the land. If you need to continue possessing it, then you must transact with the new owner. In the event that you don't, then the new owner can send you out, can come into the land, and if sued for trespass, would plead for the defense of prescription. We have act of necessity. Again, as we earlier on said, you can plead the defense of necessity and an action of trespass to land, where it was necessary. Like you can trespass to save property of your neighbor or the property of the plaintiff. You can trespass to put off fire in the plaintiff's land. That was an act of necessity. Can also plead for statutory authority. I'd explain about statutory authority. Or you can plead for entry by license. An entry that is authorized or licensed by the plaintiff cannot be actionable in tort of trespass unless the authority of the license given has been abused. So if you are allowed entry, if that authority to access the land has not been abused, then you can plead for the defense on entry by license. What are some of the remedies for trespass to land? We have damages. The plaintiff may recover monetary compensation. Damages are generally monetary compensations from the defendants, and the extent of which depends on the effect of the defendant's act on the value of the land in question. Can also pray for ejection. Ejection is where a person who wrongfully entered or remains on another person's land is ejected using reasonable force. When one is ejected using reasonable force, as granted by an eviction order or an ejection order by the court, then that is a remedy. Can also be an action for recovery of land. Action for recovery of land is another remedy. The plaintiff may bring an action to recover his land from the defendant. And where there has been a wrongful disposition, then action for recovery of land is normally a common action. Then we have injunction. Now, an injunction can be obtained to ward off a threatened trespass or to prevent continuous or a repeat of the trespass. And finally, we can plead for distress, damage, feasance. In case when the trespass is by placing things on the land, then the plaintiff has a right to detain the defendant's chattel or animals or property that had been placed on the land until when the person vacates the land. The second trespass is trespass to a person. Now, trespass to a person could be in the form of assault. It could also take the form of battery, or it could take the form of false imprisonment. There are three types of trespass to person. Assault, which is committed by a person when he threatens to use force against the person of another. When one threatens to use force against the person of another, then we talk of that as an assault. So that is an assault. Then we have battery. Assault is a use of threat. You use a threat to cause some injury. But battery goes beyond just using a threat. In assault, the threat is calculated to induce some fear. But in battery, there is the actual application of force against the person of another without any lawful justification, and this causes an actual hurt. When you use force, when there is actual application of force against the person of another to cause some harm, then we refer to that as battery. Then we have false imprisonment. False imprisonment occurs where a person is totally deprived of their freedom without any lawful justification, whether it is physical or otherwise. Like locking someone up in a room, locking the exit so that the person cannot leave the room, that is false imprisonment. Surrounding a person that it becomes practically impossible for the person to leave from where it is, then that is false imprisonment. So we have three trespasses to person: assault, battery, and false imprisonment. What are the defenses in trespass to person? We have two main defenses. One is parental authority. There are instances where a parent has a right to reasonably chastise or discipline their children. And so the children cannot sue for assault, for battery, or even false imprisonment. So that is parental authority. When an act is committed to protect the children by the parents, then it is a parental authority. However, there is a limit beyond which then it ceases being a parental authority. For instance, if a parent gets a knife and threatens that he'll cut off the mouth of that child, if the child is abusive, for instance, to adults and others, the child cannot sue the parent for assault because the parent has threatened to cut off the mouth. Then you cannot sue, the child cannot sue the parent in that instance. There's no trespass because it's the parent's responsibility to ensure that the child is disciplined, is well mannered. But if the parent goes ahead and use the knife and cause harm to the child, then you cannot plead for parental authority. That becomes a criminal offense. Then the second defense is judicial authority. Judicial authority, an act that is done under order of court is not actionable as a trespass. There are instances where we have judicial capacity not being actionable. Any act that is done by a judicial officer following a warrant or an order by the court of law cannot be brought against the person. And so you can plead for judicial authority. What are some of the remedies? We have damages, as usual. Award of damages can be done. We have other general defenses such as self-defense that can be used. You know, in some instances, you can use self-defense and use it. Then we have the habeas corpus. The writ of habeas corpus is a remedy to false imprisonment, which requires, you bring the person, the right directs the person in short, to the person who is alleged to have imprisoned someone falsely to produce the person, whether dead or alive. And the court may order for the release of the person. That is now the writ of habeas corpus. And finally, on trespass, we have trespass to goods. Now, a trespass to good is committed by a person who directly and intentionally interferes with the goods in the possession of another without lawful justice. Now, the wrongful interference may be constituted by removing the goods from one place to another, that is taking them away from the plaintiff's possession, or by using the goods, for instance, wearing the plaintiff's shirts, or by destroying or damaging the goods. That is good. Now, a finder of a lost property is not liable for trespass, where the owner of the property is not known to him and cannot be easily ascertained. But if the owner of the property is known to him or can be easily ascertained, continuous possession of that property would constitute trespass to goods. Then we have conversion, which is based on possession and is actionable only if the defendant's act was intentional, but not where the defendant was merely negligent. Now, conversion is constituted by dealing with goods in a manner that is inconsistent with the rights of the person in possession of goods or who is entitled to the possession. So those are the trespass. We have trespass to land, trespass to person, and then trespass to good or commercial. The other tort is nuisance. The tort of nuisance is committed wherever a person is wrongfully disturbed in the use and enjoyment of his land. and it generally arises from the duties owed by neighboring occupiers of land. No one should use a property in a way which is likely to affect his neighbor's use of their own. And we have two types. So we have private nuisance, we have public nuisance, and we have continuing wrong. Now, private nuisance is committed where a person's private right in his land are wrongfully disturbed, whether physically or by allowing noxious things to escape out of his land. Public nuisance, also known as common nuisance, affects the comfort and convenience of a class of persons, but not necessarily every member of the public. And a continuing wrong is a nuisance that is actionable when it becomes a continuous wrong. The other important thing is to understand the concept of plaintiff in nuisance. Now, since private nuisance generally covers only damage to property to its enjoyment, the plaintiff in an action brought to remedy a nuisance must show that he has title to or at least some interest in the property which is alleged to have been damaged or whose enjoyment is alleged to have been affected by the nuisance. Otherwise, the action will not succeed. It is also important that we remember that the law of nuisance protects only ordinary or normal persons. The defendant in nuisance, the person liable in nuisance is primarily the occupier of the premises, which are the source of the nuisance, including the tenant. Liability does not necessarily fall on the owner of the premises, although he too may be successfully sued. Then we have adopted nuisance, where a nuisance is caused by one person but is adopted by another, that the person so adopting it is liable and cannot plead that the nuisance was not created by him. And it's good you check on those. Some of the case studies have indicated there. They are quite elaborate in trying to help you understand them. Now, what are some of the defenses in nuisance? Some of the defenses in nuisance include de minimis non curat lex. De minimis non lex is the defense of triability. Triability, when there's when the damage suffered is so trivial, is so minor, is so negligible that no reasonable person would have cause to complain. There are some cases where there's nuisance, but then the nuisance leads to a damage that is so trivial, that is so minor, that is so negligible, that ordinarily any reasonable person would have no cause to complain. Now, in such instances, no such action may be maintained. And so if sued, then the defendant may plead for the defense of the minimis non curat lex. It's trivial. There are those, nuisances that could be so trivial. Then the other one is reasonable use of property. We can also plead for reasonable use of property. If the defendant can prove that the nuisance complained of resulted from a reasonable use of his property, then that defense, the action cannot be sustained. Then we have prescription. I'd explain about prescription. And finally, public benefit. Now, public benefit as a defense to an action brought to remedy a nuisance has only limited application. If it is not interfering with the private rights, which must generally be respected, then there must be a statutory authority that ordered for that action to be performed, the action of which is leading to the act of nuisance. So then it is pleaded for public benefit. The action could have been done to benefit the public. What are some of the remedies for nuisance? We have 3 remedies for nuisance. We have abatement. You know, abatement is a remedy by way of self-help. Now, a person aggrieved by nuisance is at liberty to abate or stop it. You know, bringing an act that would bring it to a stop. Performing an act that brings the act of nuisance to a stop, as long as it is done in a peaceful manner and as long as it is done with a notice and it is done within law. You can take action to bring it to an end. Then we have injunctions. Injunction is an order restraining the defendant from continuous committing the nuisance. Injunctions are normally awarded where the nuisance already exists or is impending. And finally is damage. Damage can be awarded. Compensation in monetary terms can also be done. The other tort is negligence, defined by Judge Alderson in the case of Blythe versus Birmingham Waterworks Company of 1856 in these words: the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. That is a tort of negligence. Is looked at from 2 ways. Omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do. So if you omit to do them, that is negligence. Or doing something which a prudent and reasonable person would not do. That is what negligence is. There are 3 elements in negligence. 1, the duty of care. In determining negligence, one of the key elements is the duty of care. It is important that the duty of care is established. Duty of care simply means the duty to take reasonable care to avoid acts or omissions reasonably foreseeable as likely to cause injury to your neighbor. So one element on negligence is the duty of care. Second is the breach of the duty of care. You know, in so many other business transactions, we have the duty of care. For instance, professionals like advocates, accountants, doctors, bankers, valuers, stockbrokers, etc., hold their clients a duty of care to take reasonable care in the transaction of their client's business. Failure to do this may entail liability negligence. So there's duty of care. Then there is, there's duty of care and standard of care. It is important we distinguish between the duty of care and the standard of care. Now, the duty of care answers the question whether the defendant was under any legal obligation towards the plaintiff, while the standard of care is a yardstick by which the defendant's conduct is measured and answers the question whether the defendant did what a reasonable man would have done in the prevailing circumstances. And therefore, the standard of care required of every person is that of the reasonable man. In looking at negligence, then what really matters is the standard of care that is required of every person of a reasonable man. And the duty of care is said to be breached where the defendant fails to exhibit that standard of care that is required of him or her. And so there must be a breach of duty of care in cases of negligence. And finally, is injury to the plaintiff. Now, proof of the existence of a duty of care on the part of the defendant and the breach of that duty of care by the defendant is not enough to establish negligence or liability negligence. There must be proof. The plaintiff must go further and prove that the plaintiff have suffered damage or an injury as a result of the defendant's breach of duty of care. That is important. So there must be duty of care. There must be proof of breach of that duty of care. And finally, there must be proof of damage or injury caused to the plaintiff by the defendant action of negligence. That is when an action of negligence can be sustained by the court of law. Now, there are instances where accidents occur and the victims of negligence die. What happens? Fatal accidents where the victim of negligence is dead. What happens? Negligence sometimes results in the death of the victim. Now, in such cases, obviously the victim himself cannot sue. But this does not mean that the tortfeasor is left free. The action is brought for the benefit of the members of the victim's family and may be instituted by his executor or administrator or by and in the names of the members of his family. And in some cases, the state would come in. There are instances where the state comes in to remedy that. How do we prove negligence? The burden to prove negligence generally lies on the plaintiff, who must prove that the defendant owes him a duty of care. He must prove that the defendant has breached that duty of care, and he must prove that he has suffered damage as a consequence. And so the proof of negligence lies, the burden of proof of negligence lies with the plaintiff. The plaintiff must prove that. The plaintiff must prove that, one, the defendant owed him a duty of care, the defendant breached that duty, and that the plaintiff suffered damages as a result of that whole process. In certain cases, however, the plaintiff's burden of proof is relieved by the doctrine of res ipsa locuta, where it is applicable. Where it is applicable, then it applies. Now, the doctrine of res ipsa locuta is a rule of evidence, not of law. It merely assists the plaintiff, where applicable, in proving negligence against the defendant. However, before this doctrine can be applied, three conditions must be satisfied. One, the thing inflicting the injury must have been under the control of the defendant or someone over whom the defendant exercises control. Two, there must be no evidence or explanation as to why or how the event occurred. And three, the event must be such that it could not have happened without negligence. Three conditions that must be met in order to apply the doctrine of res ipsa locuta. We have the concept of contributory negligence. It's also important we look at the aspect of contributory negligence. Now, contributory negligence means any act or conduct of the party injured which may have contributed to the injuries he or she received. The courts will look at that. Have they contributed to the injury? Have they committed some act that may have contributed to the injury suffered? And of course, contributory negligence is a defense that can be used. It is a defense that can be used by the defendant in cases where an action of negligence has been contributed by the plaintiff. If the plaintiff had a role to play, then it can be used as a defense. You know, in Kenya, for instance, the Law Reform Act, Cap 26, that states, where any person suffers damages as the result partly of his own fault and partly of the fault of any other person, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damages recoverable in respect thereof shall be reduced to such extent as the court thinks and equitable, having regard to the claimant's share in the responsibility for the damage. And this is also true, that position is true, even in cases of fatal accident where the victim is dead. We also have contributory negligence of employees. The Factories Act of 514 makes provisions relating to the guarding of dangerous machineries. And if a worker is injured because a machine is not properly guarded, the worker may sue his employer for breach of statutory duty and or negligence. However, any omission by the employer will render the employer liable to his employees, though he can plead contributory negligence as a defense in cases where the act of the employee has contributed to the action being sued for, or to the action being sued for negligence. So there is the contributory negligence of employee. Then we have the negligent misstatement. Now, the general rule is that a person is liable of negligent acts, but not for negligent misstatement. So one cannot be held liable for negligent misstatement, but can only be held liable for negligent acts. Any negligent misstatement, one cannot be held liable for. And finally is defamation. We finally look at the tort of defamation. Now, the tort of defamation is constituted by the publication of a false statement without justification, which tends to lower the plaintiff's reputation in the estimation of a right-thinking members of society, or to injure him in his office, trade, or profession, or which causes him to be shunned or avoided. That is what defamation is. Any act of publication of a false statement without justification, and the intention will be to lower the plaintiff's reputation in the eyes of a right-thinking member of the society, or it could have been intended to injure the person in his office, or in his trade, or in his profession, or is intended to cause the person to be shunned or avoided, then we refer to that as defamation. That is what defamation is. Therefore, the general rule is that no person should publish a false statement which will adversely affect the reputation of another person, if such statement is not without justification. If there's justification, then it is acceptable. But if there is no justification, then no person, the general rule is that no one should do that. There are two elements of defamation. One, the defendant must have made a false statement. Remember, no action can be maintained by the plaintiff on the basis of a true statement. So one, the statement must have been false. The defendant must have made a false statement. No true statement can constitute defamation. Number two, the statement so made must be defamatory. What it means is that it must be such that it affects, or it arouses, or it leads to a contempt or ridicule from a right-thinking member of the society. That is what it means to be defamatory. In other words, it must tend to lower the reputation of the person referred to in the estimation of a right-thinking member of society. So those two elements are important in maintaining a case of defamation against a defendant. One, the defendant must have made a false statement. Two, the false statement must have been defamatory in nature. Now, what are the functions of the law of defamation? Generally, as I've stated earlier, the law of defamation protects a person's reputation and the business interest. That is the main intention of the law of defamation, to protect a person's reputation and to protect the person's business interest. Remember that every person has a right to a good name, and no one should unduly interfere with that right. The law of defamation ensures that that is maintained. That is the basic function of the law of defamation. We have different types of defamation. The first one is a slander. Slander is defamation in a transient or a non-permanent form, which include defamation by word of mouth. When it is not permanent in nature, it's not permanent, it is transient. Exemptional circumstances of slander include where the statement imputes a criminal offense, then it is punished by imprisonment. Where the statement imputes a contagious disease on the plaintiff, where the statement imputes unchastity on a woman, and where the statement imputes incompetence on the plaintiff in his or a trade, occupation, or profession. That is considered as a slander. The second type is libel. Second type is libel. Libel is a defamation in a permanent or a non-transient form, including written matters like a letter or an article, a scandalous pictures, especially where the scandalous pictures are accompanied by defamatory statement, films or news tapes, etc. Those are considered as libels. Now, every repetition of defamatory matter constitutes a fresh course of action, and anyone who repeats it may be sued. So in defamation, every repetition of the defamatory matter would constitute a fresh course of action. So for as long as one continues repeating the defamatory matter, that is a fresh action. And for every such can be sued. A person who takes part in the distribution of such defamatory matter, whether by way of sale or otherwise, is equally liable for defamation. And so when one partakes part in the distribution of any defamatory matter, whether that is by way of sale, like newspaper vendors, when they sell newspapers, they are part of the defamation. They can be sued also as partakers of that particular act. They are equally liable for defamation. The other important aspect is defamation of deceased persons. Now, defamation of a deceased person is not a tort, but the person responsible may be prosecuted criminally if it is intended to hurt the feelings of the deceased families or their near relations. There are a number of defenses available to a defendant sued for defamation, and we'll look at some of them. Now, a defendant may, in appropriate circumstance, plead that there was no publication of the matter complained of, or that it does not refer to the plaintiff, or in ordinary cases of slander, that no damage has been suffered by the plaintiff. In addition, the defendant may avail himself at least one of the general defenses, such as the consent of the plaintiff to the publication of the matter complained of. Now, beside that, other defenses include justification. Truth or justification may be pleaded as a defense where the matter complained of is true and the defendant fails to establish the truth of the matter. Now, the case against the defendant becomes more serious, and the aggravated damages may be awarded against the defendant if they fail to prove the truth of the matter. But if they can prove the truth, then justification would be the best defense. They can also plead for fair comment. The other defense is fair comment. Now, fair comment on a matter of public interest would be one of the available defenses for a defendant in a defamation suit. Now, there must be facts truly stated on the basis of which a comment is made, and the fact must not be mixed up with the comment in such a way that it is difficult to distinguish one from the other. And also use absolute privilege. Certain matters are not actionable at all in defamation and are said to be absolute privilege. They include statements made by judges or magistrates in the course of judicial proceedings, as well as those made by members of parliament in the course of a parliamentary debate, and also communications between spouses. Those are absolute privileges. Then we have qualified privileges. Now, according to Pullman, occasion is privilege when the person who makes the communication has a moral duty to make it to the person to whom he does make it, and the person who received it has an interest in hearing it. Then that is a qualified privilege. And finally is apology or offer of amend. The defendant is at liberty to offer to make a suitable correction of the offending statement coupled with an apology and or notice of persons to whom the statement has been published that the words are alleged to be defamatory of them. What are the remedies? Some of the available remedies for defamation include damages. We can also talk of aggravated damages. We talked of damages and you know what damages are. Can also talk of aggravated damages. We can talk of apology and injunctions. Those are the common remedies in cases of defamation. However, in defamation, there's limitation of action. There is a period within which an act against a defendant for defamation may be brought up. The limitation of actions, Cap 22 contains the period limits within which the actions in tort can be brought. This act provides, one, an action in tort must be brought within 3 years of the course of action occurring. Where the damage arising from the tort does not become immediately apparent, then the time begins from the date of damage accruing. 2, where the plaintiff is under disability, such as infancy or insanity, at the time when the tort is committed, time does not begin to run until the disability ceases. 3, where the tort consists of continuing wrong, a new course of action arises daily from when the tort is committed, and the plaintiff can recover damages for any damage suffered within the limitation periods. And 4, where the right of action is based on fraud, or the right action was concealed by fraud, limitation will run from the date of discovery, or from the time of plaintiff having discovered it within reasonable ordinary diligence. An action to recover a contribution from a joint tortfeasor under the Law Reform Act Cap 26 cannot come after the end of 2 years from the date of which the right accrued to the first tortfeasor. And where there has been successive conversion of goods, it ceases after the end of 3 years from the date of first conversion. And generally, according to Defamation Act Cap 36, the period of limitation in cases of libel and slander is 12 months. Again, in tort, there's the survival of action. A common law maxim is action personalis morita cum persona. It simply means that action of a person, personal right of action dies with the person. When a person dies, then the personal right of actions also dies with that particular person. However, this act does not apply in cases of defamation, seduction, or cases which claims for damages on the ground of adultery is concerned. In all other cases, the act provides that, one, where an action exists against a person at his death, it survives against his estate, provided that the proceedings had been commenced before his death, or that proceedings are taken within 6 months after his personal representatives have taken out representation. 2, where a right of action exists for the benefit of a person, it survives his death, subject to the limitation periods in the Limitation of Action Act, Cap 22. And in cases of passing off, when a person passes off his goods or business as those of another reputable business firm, it is known as a tort of passing off. This tort can take the following forms. 1, using the name of a reputable business firm. Or 2, imitating a trademark, description, or wrapping, etc. The tort result in damaging the business interest of a firm, then the passing off applies. In this case, the plaintiff may sue not only for damages, but may also ask for an injunction. And finally, is malicious falsehood. The tort of malicious falsehood is committed when a person makes a false and malicious statement, and such statement causes a financial loss to another person. There are three essential elements of malicious falsehood. One, the statement must be false. Two, there is malice or ill intention. And three, it tends to make others act on the basis of that false statement, which leads to causing the financial loss. You know, when one acts on the basis of that statement, and that action is actually what leads to the financial loss by another person, then we talk of malicious falsehood. That is another tort that can be committed in business transaction or in the ordinary course of performing businesses. So that's about the law of tort. We've looked at the different types of torts. We've looked at their characteristics. We've looked at the defenses available to defendants, and we've looked at the remedies available to plaintiffs in all of those cases. And it's important that we be able to distinguish the different forms of torts and know when we can bring action against the defendants on all instances as provided for by law. Any question up to that point? Any question? Any question? Okay, then there seems to be no question. We will adjourn and resume tomorrow. Let's meet in tomorrow's class. Tomorrow we look at the law of contract. And probably if time would allow us, we'll basically look at the law of contract tomorrow, and then on Wednesday, we look at the contract of employment. On Wednesday, we look at the contract of employment. Tomorrow, we look at the law of contract. We look at contract of employment on Wednesday, and then on Thursday, we look at the law of agency. On Monday, we look at two areas. We look at the law of succession and the law of property. And then on Tuesday, we look at the Sales of Goods Act. And on Wednesday, we look at the hire purchase. When are you supposed to do the final exam for this session?
June 4th.
On 4th June?
Yes.
Okay, so probably by Wednesday next week, we should be done, so that you have a few days, 2 or 3 days for revision. Okay? If there's no any question, then we adjourn and let's meet tomorrow.